How you doing? This is Jeffrey Blair, attorney in New Jersey, focusing on estate planning, and thank you for joining my webinar, Estate Planning for Young Families. I've been looking forward to do this webinar for a long time. Talking with young people, even my own children in their 20s and 30s. As many young people, they don't believe estate planning applies to them. Either they think estate planning is only for the very wealthy, which it is, or that it's only for individuals who are reaching retirement, gray-haired, which it is. But it also is for anyone, any adult over 18 needs to start thinking about an estate plan. And that's why I put this webinar together. So thank you for joining me, young people in your 20s and 30s that you're listening to me, or even parents of adult children. This could be for you too, so that you can help educate your young people on the importance of estate planning from a very young age. All right, so let's get started. And in getting started, start with a question. And the question is, as you guys can see the presentation, who will speak for you when you can't speak for yourself? All right, let's go through a little scenario. And let's look at a young lady named Jessica. Jessica is 22 years old. She's a senior at Rutgers University engineering program, so she's graduating this year. She's actually from Texas, but she selected Rutgers when she got accepted. She had several acceptance letters, but she chose Rutgers because she has a aunt that lives in New Jersey, and the idea was with Jessica's parents that, hey, and if anything happens, at least she has family that's close by. So, that was 4 years ago. She's now a senior. She's going through the process of getting acclimated to college life and finding friends and finding her clique and getting in her groove. So much so that in her sophomore year she met Maxwell, and Maxwell's also in the engineering program. Pretty much they fell in love at first sight, and they've been dating for 2 years now. Actually, their senior year, they actually moved off campus and moved in together. And they met the families, and they plan to get married very shortly after they graduate. So they're fiancés. So everything is going well. But unfortunately, not too long ago, on the way home after a long study session with preparing for finals, Jessica got into a car accident. And in that car accident, she was, made unconscious. She went to the hospital. The doctors have to proceed to have some life-saving measures upon her. And the question is that we have in this type of situation when the doctors have a question about should they do plan A or plan B, and she can't speak for herself, who has the legal right to decide Jessica's care? Who has the legal right to be able to speak to Jessica's doctors in order to inform them and make decisions for Jessica? Is it Maxwell, her live-in fiance? Is it her aunt that lives nearby? Is it her parents who are back home in Texas? Who makes the decisions for Jessica when she is not able to make them for herself? Well, the point to this little exercise is that, without an estate plan, without documenting her wishes, it's going to be confusing. It could be problematic, and it could be very tense and stressful for the family members and for Maxwell, and for the doctor, not really understanding, okay, who really is in charge, who can make these decisions. Many people don't think sometimes that those type of decisions are also a part of your estate plan. It's not just about money, but it's also about what happens to you and to your loved ones. So in this webinar, this was just an illustration to kind of show you the importance of an estate plan. In this webinar, you're going to find out what are some of the minimal requirements for a young adult when it comes to an estate plan. How to protect your first home, right? You're going to be in that stage eventually, buying a home. How to name guardians for your minor children. The difference between a will and a trust, and how to protect your inheritance. So these are some things that are relevant to a young person or a young family. And I wanted to, take time to be able to kind of talk about some of these topics with you, and hopefully you find value in them. All right, so let's get started. If you stay to the end, also there's a bonus, so don't click out. We have some good information here, as well as a bonus at the end. So who am I? I'm Jeffrey Blair. I'm an estate planning attorney in New Jersey, and this is my passion. You know, this all started when I was actually working on doing an estate plan for my mom, and right now she's 93. And you know, I realized just, man, there's so many things that if you put them in order now, it'd be so less stressful, you know, when they're needed later on. And so I went down that path, started talking to people, even other attorneys, and like, they didn't really have a lot of information about, you know, estate planning. And it's a vital process and vital information that I think all households need to have, so that they can make good decisions about themselves and about their family moving forward. So it's a passion of mine. It's my focus. It's all that we do in my law firm. So if you decide to move forward with us, you know, you'll be in good hands. So first, let's start with a definition. What is estate planning? All right, I'm gonna just read the slide because I think some of the terms there are very, very vital. Estate planning is the vital process of legally documenting a strategy to protect your wishes, your assets, and your loved ones during your life and beyond, securing your legacy and ensuring peace of mind for those who matter most. Let that digest for a second. So you see what's highlighted there. It's strategy to protect your wishes, your assets, and your loved ones. And it's important because I think, you know, when you go online, sometimes you may find some, you know, companies out there that will maybe have you create some documents, maybe, you know, LegalZoom or those other type of companies on your own, DIY they call it, right? Do it yourself. And I strongly urge you against utilizing DIY when it comes to legal documents. Number one, a lot of these things dealing with estate planning are state specific. It's not one size fits all. And so a legal document that is executed in New Jersey, if it's not executed properly, it may not be honored in another state. It may not have all the terms that are necessary to make it valid. It might not be executed properly. And it may not fit your specific situation, you know? Through my practice, speaking with other attorneys through their practice, there are no two people who are exactly the same. Everybody's situation is different, and therefore your estate plan needs to reflect that. And that's why it's a strategy of putting together you know, an estate plan. It's not just about the documents. So the way I work is, if we work together, we would sit down, you know, through a Zoom session similar to this. You would tell me about the things that you are interested in, things that concerns you. I will let you know what the legal processes are, what the legal options are, and then you would decide which direction you'd like to go, which pieces you'd like to put together. You don't have to do everything at once. You can do one thing at a time, but the point is it would be specifically tailored to what you need, and a strategy based upon your concerns and your wishes. That's what an estate plan is supposed to be. You can't get that from a do-it-yourself service. So it's important that I think that you look at that. Another word I wanna focus on here too is assets, right? Strategy to protect your wishes and your assets. When you hear that word, many times people think only about, you know, your house, your bank account, your investments, you know, things like that, your assets. But you know, the following, you know, my mentor and my elder, one thing he would note is like, you know what your greatest asset is? You know what your greatest asset is? Your greatest asset is yourself, right? Yourself. That's why going back to Jessica's situation where the question was, who's going to speak to you for you on your behalf to protect your most valuable asset when you can't speak for yourself? That's a part of estate planning. It's not just about the funds, it's also about yourself. It's about your health. It's about what happens if I'm incapacitated. You know, what happens to my children if I'm not able to take care of them. All that is a part of estate planning. And so I think those are some notions that many times people don't understand, and I want to make sure I share that with you so you do understand why it's important that you have clarity about what exactly the scope is of estate planning. It includes yourself, it includes your health, it includes your life, it also includes your physical assets such as you know, your homes and your cash and your investments, so on and so forth. All right, so hopefully that makes some sense as you get to this definition, as you get through this definition. And let's move into the next slide. So going back to the an original scenario that Jessica found herself in, unable to speak for herself, in a critical situation where you need someone to be able to make decisions for her, not decisions that they would like, not what Maxwell wants, not what her aunt wants, not what her parents want, but what does Jessica want, right? Everybody's going to be guessing what does she want to have stuff happen. Well, a part of estate planning is a document called, in New Jersey, it's called an Advanced Healthcare Directive. And again, it's a legal document that you put together before you need it. That's the thing about these documents. You put it together now before you need it. So when you need it, it's there. And it can alleviate a lot of confusion and alleviate a lot of stress and a lot of conflict that can take place. And sometimes legal bills as well. So Advanced Healthcare Directive, a legal document, provides instructions for medical care and only goes into effect if you cannot communicate your own wishes. And there are two parts to that. There's the living will, which is a legal document which talks about what type of treatment you decide that you will or will not want to partake in, as well as a healthcare proxy, and that's naming someone that this is the person that can make these decisions for me if I can't make them for myself. And it's a legal document. We would sit down, we would go through this, details of it, and then we would, get them executed in a proper way. And then once these are set, now everyone is clear about if anything was to happen, these are her wishes. If anything's to happen, this is the person I want to make decisions for me because I've already spoken to them about what, my mindset about what I'm thinking when it comes to my health care. So if this was in place, very easy to do, it's not very expensive, but if this is in place, that's a protection that can alleviate a lot of confusion and conflict down the line. All right, let's go on to the next slide. What about the money, right? There's another part to this, right? Let's say Jessica, the question about who makes decisions on healthcare, that's the part of it, Advanced Healthcare Directive we just spoke about. What about her finances? What about her investments? She's not able to make those type of decisions at this time. Who knows how long this will go on? Can Maxwell just go into the bank and start transacting on her behalf? Can her parents? Can her aunt? No, because she's an adult. And, as far as her investments, paying her bills, doing her online banking, all those various things, she would have needed to have a power of attorney set up prior to this so that that individual that's indicated in the power of attorney would be able to then transact business for her. And it could be her investments, it could be her banking and checking account, it could be paying her bills, it could be accessing her paycheck or any of those things. Setting up a power of attorney now, before she needs it, would then be able to have it go into effect when she needs it. And therefore, she can avoid a lot of financial issues because trying to figure out who's going to be doing what and who has access to what, you need to have a power of attorney to take care of those finances. So a durable power of attorney in New Jersey is a legal document that allows a named person to make financial decisions on behalf of another person, even if that person has become incapacitated or unable to make decisions, right? So as a young person, as you have right now, those are two documents, but it's when you're 18 that you need to have a power of attorney and an Advanced Healthcare Directive. So I just want to give you a glimpse. Those are just two samples, two portions of estate planning. We didn't even get to anything about a will or anything about, a trust or anything like that. Just very basic. These are some basic things that you should have, some foundational items you should have. And just overall, hopefully it makes sense as to why estate planning is so important. Number one, ensures that your wishes are honored. If you're in a situation where you can't speak for yourself, it won't be someone else's wishes, it'll be what your wishes are, and those can be documented. Protect your loved ones and your assets, again, starting with you, you're your most valuable asset. Avoid legal hurdles. Like many times if family members can't decide about what happens to Jessica, then comes legal battles, and then a judge will have to decide, who has the authority to make this type of decisions from, and you want to avoid it at all costs. Avoid family disputes, provide for minor children, which we're going to get to in a second, maintain privacy, right? And save time and stress. The idea is like when you have your estate plan set up, Now you have a little bit of peace of mind. No one knows what tomorrow may bring, but at least you can know if anything does happen, at least things are going to be taken care of. I've already thought this through, and I have an estate plan that can be executed that would at least allow my loved ones to, go through this process as smoothly as possible. And that's what estate planning is all about, giving you peace of mind. So the question, to follow up on what was mentioned in one of those other items about, well, what about minor children, right? How are they handled? Well, let's ask the question. What would happen to your children if something happened to you? What would happen to your children if something happened to you? Well, if you don't have a plan in place to answer that question, and God forbid, but if something does happen, you're not able to care for them for some reason because of illness or because of some type of health issue, then if you don't have a plan, there is a default plan in place, but it involves the court, and it involves the court, and you probably won't like it because it's not necessarily going to follow your wishes. They're going to make decisions that could maybe give it to a family member that you are not in good terms with, and may go to a stranger that they may deem to be the best interest of the child, and someone that it can be very messy. These have been very messy type of situations, guardianship proceedings, and so the best thing to do is to get ahead of that type of situation. If you never need it, then fine, it just stays away, in the drawer. But if you have it in place, it's better to have it and not need it than need it and not have it, because it can become very messy. All right. The solution again is in your last will and testament. This is probably one of those estate planning documents that most people are aware of, right? A will, right? You've seen it in the movies, seen it on TV, right? Someone passes away, they have a will, they pass on their assets, their things, right? The tangible items, right? So-and-so gets my car, so-and-so gets my mink, so-and-so gets my house, things like that, right? But, I'm not sure if you knew, but also your will is also the place where you designate, if I pass away and not able to take, and my minor children, I can elect who I want to be a guardian for my minor children. Again, the idea is making sure that your wishes, that you've thought through this, and in the case that something happens but you can't take care of them, you have already indicated that this is an individual I want to take care of my child. You can even indicate, and here's why. You can even indicate, here's why I don't want X, Y, Z to, be the guardian, so on and so forth. So you can indicate your wishes and your preference for your children, and unless there's some weird reason why not, usually that's what the court will honor. So it's important, again, do these things ahead of time before you need them, so just in case they are needed, you can have peace of mind that they will be taken care of. And also, sort of relatively new item added to estate planning is digital assets. Even what we're doing right now, right? Most of our life, a lot of times, is spent online. So whether we're talking about our email presence, our social media presence, we're talking about our banking online, investments online, Robinhood and different other types of things, cryptocurrency, there's so much that's happening online. Well, what happens if you're incapacitated and can't access it anymore? Or if you pass away, what happens to everything that's there? Maybe some valuable information that may be there on your phone, that can be there on your social media, that might be there in your email. Well, unless you put plans in place, it can be very difficult for your loved ones to be able to access those things. I mean, let's not even talk about cryptocurrency, right? But if a part of estate planning, if you think ahead, if you plan ahead and start to document some of those things, now, if something like that happens where you're not able to access it due to incapacity, or maybe you may pass away, you've already put someone in place that will be able to take care and step in and be able to access. And all these other companies have a process in place that, hey, if this individual is not able to access it and they have someone with a power of attorney or some other process through a trust or through a will, they have a mechanism to honor that so that they would give that person access to your digital assets. So again, that's one of those things where you want to make sure you put these things in place before you need them, so that just in case you do need them, they're already there. So some of the things, just want to do a little summary of some of the things that we've already spoken about. As a young person, right? We're not talking about someone who has a lot of assets, some millions and millions of dollars of homes and things like that. Obviously, they that type of person definitely needs estate planning. But even someone who's just starting out to build wealth, you want to make sure you protect what you have and put the foundational pieces in place so that even as you start to build your assets over time, including yourself, that you have that protected. Because the worst thing you can do is you have a great plan in place, you're making the right moves and right steps, but then the unforeseen happens and now it just totally topples that whole plan. But if you have a protection in place, then it can help you to withstand some of those items that may come across in life and allow you to continue forward and to see yourself through those issues because you've had an estate plan put in place. It's very, very important that we think about these things. We talked about a will, we talked about the power of attorney, we talked about a healthcare directive, protecting digital assets, and a living trust, which we're going to talk about in a second right now. But these are some of the items you need to be thinking about when it comes to an estate plan. And again, you don't have to do everything at once. And it's just like an initial conversation. I just want to spark the interest in you. The idea is that schedule time with me. We can talk one-on-one, understand your situation, your concerns, and then we can activate those pieces that makes most sense for you at this stage in your life. I'm going to talk a little bit about Irrevocable Living Trust and why this is just so important. And this is a very valuable tool when it comes to estate planning. Now, when we talk about a revocable living trust, I want to make sure there are many different types of trust, but this specific one that's a very valuable tool that could be utilized, especially with someone that's just starting out to help protect them in a lot of different ways. So, a revocable living trust is a legal document that allows you to transfer assets into a trust while maintaining control during your lifetime to ensure a smooth transfer of assets to your beneficiaries after you pass. But also the piece of that too is it also goes into place even if during your life. That's why it's a living trust. While you're living, you put it into action, and it also protects your assets not just when you pass away that it's going to go to your beneficiary smoothly, but also if you become incapacitated, if you become disabled, because your items are in a trust, they also are protected and also will be able to move smoothly on to the next stages as opposed to if they were not. So there's so many benefits here. I'm not going to go through all of them. Avoiding probate, which again is helps keep it private, helps keep it a very smooth transition if it had to go into your beneficiaries. Manage assets during incapacity, protects your privacy, provides for minor children, ensures continuity of asset management, minimizes estate taxes depending on what your situation is. Protection against creditors, for your beneficiaries. There's a lot of benefits to revocable living trust. And one of the things that, we look at many times is a will is very valuable. People are very familiar with wills, but there are certain situations where a will sometimes is not enough. And that's why the trust ends up becoming a very good vehicle to address some of those concerns. So we look at a couple of them. So where a will fails, let me just move the camera a little bit so you guys can see the full reading. Wills have to go through the probate court. So some people don't understand. I think that, okay, if I don't have a will and I die intestate without a will, well, yeah, you gotta go to probate because the judge has to decide who's the executor, have to decide, how much assets do you have, are there any creditors that need to be paid before anything is passed on to the next, to your beneficiaries, so on and so forth. And people think, okay, well, I have a will, I can layer that out. And will says, I want so-and-so to be an investment executor. The will says, I want, so-and-so to get this, so-and-so to get that. But even with the will has to go through probate, and the judge has to approve the will. So even if you have a will, you still have to go through probate. A trust avoids probate. So that's one benefit that you have from that. Also, a will doesn't go into effect until you pass on. So everything you say in the will, as you mentioned earlier on, incapacity and disability, a will does not take effect into that. It only after you pass. A trust allows you to make decisions and management about your assets even while you're alive during incapacity or disability. So that's one thing. Problematic if you cross state lines. So if I own a property in New Jersey, own a property in Florida, own a property in Texas, my family have to go through probate in all three different states. If I was to take those properties and put them into my trust, I no longer have to worry about probate, and they can pass on to my beneficiaries about the issues of those different state laws that takes place. Kids get money at 18 in a trust, in a will. You would say, hey, so and so gets this, so and so gets that, so and so get this, and that's it. They get it outright. But if you have some funds or even an insurance policy, do you really want to give that amount of lump sum to an 18-year-old? You probably want to have some type of control over that. Maybe they get a certain portion at a certain age. You can't do that in the will. You would do that in a trust. Provide direction and protection for a short term after death, not during your life, not for the lives of the surviving spouse, children, and grandchildren. So again, the idea, wills are great, necessary part of just about every estate plan, but in addition to that, a trust can be very valuable as well for a lot of people. So let me give you an example. Bob has one asset, just to make things simple, $100,000 in the bank. And he wants to leave it to his son, Fred, when he dies. But he doesn't want Fred to get the money until he's 18 years old and until he graduates college, right? He wants to make sure he has certain maturity, makes sure that he accomplishes some things, before he does that. Bob needs trust, right? As I mentioned before. And let me just go a little bit to kind of show you a little bit about how a trust actually gets set up. So a trust, you can think about it as a bucket, okay? And so here are you, and you're going to create and manage the trust, right? And I will take you through that. It's all the setup process, right? How you would create the trust. And the idea is it's a legal document. It's basically a contract. And once you create it, you would have yourself would create it and then manage it. But then you also would have a successor trustee, right? The trustee is the person who manages it. So you're the first trustee, but then you'd have a successor trustee. So maybe it'd be me as my major trustee, and then maybe my wife as successor trustee, or my brother, or someone else that would be another trustee, right? And you'll see when that comes into play in a second. And the idea is I'm setting up a trust, and I'm saying anything that's in this trust is for the benefit of my beneficiaries. It could be my children, it could be a charity, it could be whatever it is. But when I pass, everything that's in this trust, I want to go to my beneficiaries, right? So it sounds similar to a will right now so far, right? And so once it's created, the next thing that you have to do is that you have to what's called fund it. And so whether it's a home or assets, different assets you may have, investments, accounts, things like that, you would fund and put the items into the trust. So therefore, anything you put into the trust would follow the rules of the trust. Anything you don't put in the trust would just be part of your estate and would pass on as under your will. So that's how you would set it up. So hopefully the visualization helps a little bit, but we'll kind of go through this just to maybe give you an understanding of how a trust works. All right, so now let's say you become incapacitated. So as you become incapacitated, then the management of the trust moves from you because you're not able to speak for yourself for whatever reason. You can't manage it anymore for that reason. Maybe you're unconscious or whatever it may be, that you're not able to do it, manage your finances for yourself. Then the successor trustee steps in, right? And this is already outlined in the contract of the trust, and they're able then to manage whatever is in the trust. We already put the real estate in there, as we said from the last slide, and for the same thing, for the benefit of the beneficiary. So therefore, this is a private thing. You have to go to court for this. It's already in the contract. Everyone's aware of what's going on. This person can now affect business, as needed for whatever's in that trust on your behalf for the benefit of the beneficiaries, right? That's what happens if you're incapacitated. That's the value of it. You don't have to wait until you pass. But even if you're disabled, you have someone that can manage everything that's in the trust for you. Hopefully that makes sense. Now, what happens if you're deceased? If you're deceased, your successor trustee continues to manage whatever's in that trust for the benefit of your beneficiaries. And the idea again is that you're giving it to your beneficiaries in trust as well, and the trust that you're giving it to them for ends up becoming a separate trust that they can benefit from, but because it's in the trust, it's now protected. So if any of the beneficiaries ends up getting divorced, a spouse cannot then get their inheritance or part of that, whatever's in that trust. If the creditors or people already have sued for a lawsuit, because the items are in the trust, it's protected. There's a wall of protection that's there. They cannot get to it. If they have back taxes, even Uncle Sam can't get to it. If the beneficiaries have special needs, because the funds are in the trust, it doesn't preclude them from not getting government assistance as they were getting. Like, if you give them a lump sum, now they're no longer qualified to get government assistance, right? But because it's in the trust, it's protected. So trying to give a visualization of this to get a sense of like the power of a trust, and I'm just scratching the surface here. There's so much to it, but again, it's very situation specific, and we can customize the trust to fit just about any type of situation. And that's why I'm taking some time to talk about this, because I think it's very valuable. So even yourself as a young person, you start to buy your first home, you want to think about putting it into a trust for a lot of different reasons. But also, if you're in line for inheritance of any kind, and this is where you can talk to your parents or your grandparents. Maybe there's life insurance, maybe there's a home, maybe there's anything like that that will be passed down to you. Talk to them about putting it into a trust for you, because that will help protect you when you receive that inheritance, in case any of these things that may happen to you in your life. So if again, we hope any of these things happen. We hope you never have to go through divorce. We hope that you never have issues with creditors or lawsuits, right? We hope that you never have issues with tax or anything like that. But to protect your inheritance, ask your parents and grandparents to put it into a trust for you, so that it will protect you in case anything happens. You end up getting divorced, you don't have to worry that your inheritance now is going to have to be split in half, with your ex-spouse. But it stays contained in its own bucket, and you can still benefit from it, but your creditors or anyone else cannot get it from you. Hopefully that makes sense, and we can discuss it in more detail if you have questions about this. Here's an example. Harry and Wendy have 2 children, Denise and Sam, right? Meet Jason, right? Jason is Denise's husband. He's, I guess you would call a couch potato, a cat potato, right? Kind of lazy, doesn't do anything, just a bum. So if Denise inherits funds from her parents directly, they pass on, here's $100,000, here's the house, here's life insurance, coming directly to you. Well, if they end up getting divorced, Jason gets half of that, half of the money, that you've worked for. You don't want that, right? But putting into a trust, you protect Denise from people like Jason. Similar situation. Sam is accident prone. Sam accidentally left the water running in his bathtub and went out for the night. His downstairs neighbor sued, and Sam lost his entire inheritance, settling the claim. Again, putting it into a trust protects Sam, protects the inheritance, from Sam's negligence. So I just want to give a couple examples of that to kind of give some perspective on that, why this is so valuable for you as you buy your first home. But again, also speak to your parents and grandparents, because if you're going to be inheriting anything or getting insurance proceeds from anything, make sure they put it into a trust for you. All right. I've given you some information. Hopefully it's been valuable information. Now the question is, what are the next steps, right? Knowledge is not enough. You want to make sure that you have an action plan. So what do you need to do? How do you make it happen? Where do you start? What's the investment? How do I get it done right? Those type of things. It's very good questions, and I'm here to answer those questions. So let you know what estate planning is. The way working with me in my law office is that we go through a process. First, we sit down. Number one, it's called a peace of mind planning session. That's where, again, we sit down. I listen to you, listen to your questions, answer your questions, understand what your concerns are, let you know what the law is as far as how it applies to you, some of your options that you can, put into place. Again, it may not be everything at one time. Maybe you do one part now, do one part later. Sometimes it's triggering events. When I buy my first home, this is what I want to do. When I have my first child, this is what I'm going to do. Different things like stages. That's fine. The point is, it's about having a strategy put in place. That's what we're talking about. And then we put together a design meeting where, based upon what we discussed and we decided we could work together, I will then put together that, and we will design the plan for you. And then we would review the legal documents, and then we kind of go through a signing ceremony, right? Where we kind of go through, it's a big deal, right? Putting this in place is really a big deal. And so we have a signing ceremony where we make it official, we execute them according to the laws that make them valid. And then from that point forward, we're good to go. Ongoing then, you have an estate plan, again, things change. Your life situation can change. You can get married, maybe get divorced. divorced, have children, whatever. The laws could change. All these various things could happen. So, annually, I would do a review to make sure they still match your situation. They still match the laws, and just to make sure that they're very valid, right? The last thing you want to do is have an estate plan that's like, outdated. We did it 5 years ago, but guess what? The laws changed, or your situation has changed. So you want to make sure that they reflect reality, right? So when we work together, we're working on all 5 of those pieces. So you've got to the end. Got a couple more slides, but thank you for sitting through this. Hopefully you find some valuable information here. And so now here's the bonus. Here's the gift for sitting through this. If you book that first session, that peace of mind planning session by the end of this month, I'll be able to give you $250 off your full estate plan package, right? So we sit down together, you decide we want to work together after answering your questions, giving you your options, then you'll be able to take $250 off that full package when I create that estate plan for you. So hopefully take advantage of this and just schedule that first meeting with me by the end of the month, and you'll be able to take the first steps. All right, so no more excuses, right? Can't say you're too young. It's not just for the wealthy. Hopefully I explained all that for you. Now it's on you to kind of take those first steps. And here's the QR code. You can get me at jeffreyblairlaw.com, jeffrey@jeffreyblairlaw.com, and plan that peace of mind planning session by the end of the month, and to get that discount on your packages. And I look forward to helping you. Thank you again for sitting through this presentation. I hope it was helpful. Take care.